There were a few Supreme Court decisions issued today, two of interest. The first one we'll talk about is AJT versus Osseo School District. AJT is a teenaged girl who suffers from a rare form of epilepsy. She has seizures typically in the morning and really can't start school until around noon. There are three relevant statutes: the Rehabilitation Act, the Americans with Disabilities Act, and the Individuals with Disabilities Education Act, which is called IDEA. AJT was in fact accommodated at one school district, and she got instruction from noon until around 6, going until the evening hours past when students are typically in school. However, when she moved to the Osseo School District, that was not the case, and her parents sued on her behalf. That lawsuit was brought under the IDEA Act, and she won, and she was given educational services starting at noon until around 6. Then her parents sued under the Americans with Disabilities Act and the Rehabilitation Act. There, they asked for a permanent injunction, reimbursement for certain costs, and compensatory damages. There, she did not win. Why? Well, there's an Eighth Circuit Court of Appeals case. It's called Monahan versus Nebraska, and it requires that the plaintiffs under educational cases prove conduct by school officials rising to the level of bad faith or gross misjudgment. The court notes, though, that high standard is not required under the ADA and the Rehabilitation Act for any non-educational type discrimination. Instead, courts require a showing of deliberate indifference. What is that? The court says a standard requiring only a showing that the defendant disregarded a strong likelihood that the challenged action would violate federally protected rights. Nothing, the court says, in either of those two statutes requires proving a higher standard in the educational context. The court notes that children with disabilities and their parents face daunting challenges on a daily basis. And the court said this: "We hold today that those challenges do not include having to satisfy a more stringent standard of proof than other plaintiffs to establish discrimination under Title II of the American with Disabilities Act and Section 504 of the Rehabilitation Act." The vote was 9-0. Justice Thomas wrote a separate concurring opinion. Justice Kavanaugh joined, and Justice Sotomayor wrote a separate concurring opinion with which Justice Jackson joined. The next case I'll talk about is a case where the FBI raided the wrong house.